You are driving home from a company dinner. It's a Tuesday night. You had 2 glasses of wine over the course of a 3-hour meal. You feel perfectly fine. You are not swerving, you are not speeding. You are maintaining your lane perfectly. But you have a burnout license plate bulb that you didn't even know about. Suddenly, red and blue lights flash in your rear view mirror. You pull over, confident that this is just a minor equipment violation. The officer walks up to your window. He leans in. He smells the faint scent of wine mixed with your dinner breath, or maybe just the onions from your burger. He shines his flashlight into your eyes and asks the question that ruins thousands of innocent lives every single weekend. Good evening. Have you had anything to drink tonight? You pause. You want to be honest. You've been taught that honesty is the best policy, and that if you have nothing to hide, you have nothing to fear. So you look him in the eye and say, "Just a couple of glasses with dinner, officer." Boom. You just made your first fatal mistake. You just admitted to consuming alcohol prior to operating a motor vehicle. That admission alone gives him the legal justification to extend this stop from a simple ticket into a full-blown DUI investigation. Now the officer smiles, acting helpful and polite. He says, "Okay, thanks for being honest. Just to make sure you're safe to drive tonight, I'm going to need you to step out and perform a few quick tests. Just follow my finger with your eyes and walk a straight line. It'll only take a minute." Most drivers think they have to say yes. They think that passing these tests proves they are sober. They think, "I'm an athlete. I have good balance. I can do this." Here is the terrifying reality I've learned from analyzing over 1,000 DUI arrests and body cam videos. These tests are not designed to prove you are sober. They are designed to prove you are drunk. Let me repeat that because your freedom depends on understanding this distinction. The standardized field sobriety tests are a rigged game. Even if your blood alcohol content is 0.00, you can fail these tests. Do you have bad knees? You fail. Are you overweight? You fail. Are you 65 years old? You fail. Are you nervous because there is an armed agent of the state staring at you on the side of a dark highway with semi-trucks flying by at 70 miles per hour? You fail. Today I'm going to show you why the roadside agility tests are scientifically set up for failure, the exact phrase to legally refuse them without losing your license, and how to survive the DUI investigation trap without giving them the evidence they need to convict you. I'm a criminal defense attorney. I have watched body cam footage where completely sober people, grandmothers, college students, construction workers, were arrested for DUI solely because they couldn't stand on one leg for 30 seconds perfectly. The officer didn't have a breathalyzer result yet. He didn't have a blood test. He just had their performance on a test that uses subjective grading criteria that you don't even know exist. And once you are arrested based on these tests, the nightmare begins. Your car is towed. Your mugshot is online. You spend thousands on bail. And even if you blow a 0.0 later at the station, the arrest is already on your record. Let's jump right in. The officer asks you to step out. He wants you to do 3 specific things. These are the standardized tests approved by the National Highway Traffic Safety Administration. They are the horizontal gaze nystagmus, the walk and turn, and the one-leg stand. Here's what they don't tell you. In almost every single state in America, these roadside agility exercises are 100% voluntary. You are not legally required to do them. But the officer will never, ever tell you that. He is trained to phrase it as a command or a casual request. He will say, "Step out here and let's see if you can walk a line for me." If you agree, you are handing him evidence. You are giving him a blank check to interpret your body language as guilt. Let's break down exactly how these tests trick you, so you understand why trying your best is a losing strategy. First, the eye test, or HGN. The officer holds a pen in front of your face and asks you to follow it with your eyes without moving your head. He is looking for nystagmus, which is an involuntary jerking of the eyeball. He believes this jerking is caused by alcohol. But do you know what else causes nystagmus? Caffeine, fatigue, eye strain, flashing police lights, wind in your face, or just natural biology. Here's the kicker. You cannot feel your eyes jerking. You have no way of knowing if you are passing or failing. The officer is the judge, jury, and executioner of this test. He marks down 4 clues of intoxication, and there is no video evidence to prove him wrong because the body cam cannot see your eyeballs from 6 feet away. You stand there thinking you did great, while he is already mentally writing your arrest report. Next is the walk and turn. This is a divided attention test. It is not testing your balance. It is testing your ability to follow complex, rapid-fire instructions while under extreme stress. He tells you to take 9 heel-to-toe steps down a line, turn in a very specific way, and take 9 steps back. He tells you to keep your arms at your sides, watch your feet, and count out loud. Here's how they grade you. If you start the test before he finishes the instructions because you are nervous, that's a clue. If you raise your arms more than 6 inches for balance, that's a clue. If you leave a half-inch gap between your heel and toe, that's a clue. If you turn right instead of left, that's a clue. If you stop to ask a question, that's a clue. Get 2 clues, and according to their training, you are impaired. I have seen Olympic gymnasts fail this test on video. Then comes the one-leg stand. You have to lift 1 foot 6 inches off the ground, look at your foot, and count for 30 seconds. Try doing that right now in your living room. Now imagine doing it on the side of a sloping gravel road in the dark, with headlights blinding you, while you're terrified of going to jail. If you sway, fail. If you hop, fail. If you put your foot down once, fail. The officer is building a case. He is gathering what we call probable cause. He needs enough clues to justify arresting you and demanding a chemical test. By agreeing to do these gymnastics, you are handing him that probable cause on a silver platter. So let me paint the picture of how this usually goes wrong for 99% of drivers. The officer asks, "Have you been drinking?" The driver says, "Just 2 beers." The officer says, "Okay, step out. I just want to check your eyes." The driver thinks, "I'm sober, I'll show him." The driver steps out. The officer waves the pen. The driver's eyes jerk because he's tired. Fail. Then the officer says, "Walk this line." The driver tries, but he's wearing dress shoes and the road is uneven. He stumbles once. Fail. The officer says, "Turn around. Put your hands behind your back. You're under arrest." Later at the station, the driver blows a 0.04. That is half the legal limit. He is legally sober. But guess what? In many states, the prosecutor can still charge him with DUI, less safe. They will argue in court. Ladies and gentlemen of the jury, we don't care what the breathalyzer said. You saw the video. He couldn't walk a straight line. He couldn't follow instructions. He was impaired. And the jury, like watching that unflattering video of a nervous person stumbling in the dark, often convicts. You can lose your license and get a criminal record even if you were under the limit, all because you agreed to dance for the officer. Now compare that nightmare scenario to the right way, the survivalist way. Same situation, same burnt out light, same smell of dinner on your breath. Officer, have you been drinking tonight? You, I prefer not to answer questions. Officer, I smell alcohol. Step out of the car. I need you to walk a straight line for me. You. Officer, are you asking me or ordering me to step out? Officer, I'm ordering you. You. I will step out. You exit the vehicle. You close the door behind you. You lock it. You put the keys in your pocket. You stand calmly. Officer. Okay, stand right here. I want you to follow this pen with your eyes, then walk that line. You. Officer, I politely decline all field sobriety tests. The officer will not like this. He might raise his voice. He might threaten you. Officer. If you don't take the test, I'm going to have to arrest you based on what I see. If you're sober, just prove it. You. I understand, but I respectfully decline any roadside exercises. I am willing to take a chemical test if required by law. Did you hear that distinction? That is the $1 million sentence. I refuse the roadside exercises, but I will take the chemical test. This brings us to the most critical legal concept you need to understand: implied consent versus voluntary participation. This is where 90% of drivers get confused and lose their license. In almost every state, when you get a driver's license, you agree to implied consent. This means if you are arrested for DUI, you must submit to a chemical test, usually a breathalyzer machine at the station or a blood draw. If you refuse that chemical test after being arrested, the state will automatically suspend your license for 12 months or more, regardless of whether you are innocent or guilty. However, that law does not apply to the roadside gymnastics. The walk and turn, the one-leg stand, and the pen test are preliminary searches. They are voluntary. Refusing them generally carries no penalty in most states. So the winning formula is simple. Refuse the gymnastics, take the science. Refuse the walk and turn because it is subjective, unfair, and opinion-based. Agree to the chemical breathalyzer at the station because it is objective and science-based. Why is this better? Because without the video of you stumbling and without the officer's notes saying your eyes were jerking, the prosecutor has a much weaker case. If you blow under the limit, say a 0.05, and there is no video of you failing a balance test, the charges are often dropped. But if you blow a 0.05 and there's a video of you falling over during the one-leg stand, you get convicted. See the difference? Now let's talk about the final trap. The friendly conversation in the back of the car. Let's say the officer arrests you anyway because he smelled alcohol. He puts you in the back of the cruiser. The camera is still rolling. He turns off the tough cop persona and turns on the nice guy persona. He says, "Look, man, you seem like a good guy. I'm just doing my job. Between you and me, how much did you really have? If you tell me the truth, maybe I can help you out with the judge." This is a lie. He cannot help you. He is gathering the final nail for your coffin. If you say, "Okay, honestly, I had 3 glasses of wine," he will add that confession to the report immediately. Your response in the back of the car should be total silence. Officer: "So, was it beer or liquor?" You: "I invoke my right to remain silent." Officer: "You don't have to be difficult." You: Silence. Let's recap the complete protocol for a DUI investigation stop. I want you to memorize these 6 steps. Step 1. When asked, "Have you been drinking?" do not say 2 beers. Say, "I prefer not to answer questions." Step 2. If ordered out of the car, comply. But close and lock your door to prevent an unauthorized search of your vehicle. Step 3. When asked to follow the pen, walk a line, or stand on one leg, say, "I respectfully decline all field sobriety tests." Step 4. If he asks to blow into a small handheld device on the side of the road, called a PBT, in most states, this is also voluntary. Ask, Is this voluntary or mandatory? If voluntary, decline it. Step 5. If arrested, stay silent. Ask for your attorney immediately. Step 6. If asked to take a certified chemical breath or blood test at the station or hospital after arrest, say, "I will comply with the chemical test required by law." Police officers are trained to gather evidence. Field sobriety tests are not designed to exonerate you. They are designed to incriminate you. They're designed to make you look drunk, even when you are sober. Don't help them build a case against you. Your balance is not a crime. Your nervousness is not a crime. Your bad knees are not a crime. But your words can be a confession. And your attempt to walk a straight line on a gravel road in the dark can be the evidence that convicts you. Memorize the phrase, "I respectfully decline all roadside tests." It might feel awkward, it might make the officer angry, but an angry officer is better than a DUI conviction on your record for the rest of your life. An awkward 5 minutes is better than a year of license suspension and thousands of dollars in fines. Remember, this is educational content only. Laws vary by state. Check your local implied consent laws specifically. But in the vast majority of America, this strategy is your best defense against a wrongful arrest. Stay safe. Know your rights. And never ever perform gymnastics on the side of the road for the police. If this video opened your eyes to how the system really works, hit that like button so YouTube shows this to more drivers. Subscribe for more legal survival guides. And most importantly, share this with your friends and family. You might just save them from a nightmare. I'll see you in the next one.